Today, Wisconsin's highest court heard strong arguments about new abortion laws that could have serious effects on young women, assault survivors, and people facing medical emergencies. Justices asked tough questions, looking closely at how these laws might impact real people.
Woman who is a college freshman here at the University of Wisconsin-Madison, if she is sexually and is charged as a third-degree sexual which intercourse without consent. If she became pregnant as a result of the sexual, it would be illegal for her to obtain an abortion.
Be illegal for a doctor to provide an abortion to her in the state of Wisconsin, correct?
Were she to obtain an abortion after quickening, the penalty would be 15 years. It's a Class E felony.
After quickening under 940.04 sub 2 sub A?
Yes.
I believe that's how it's defined, yes.
If her is charged, a third-degree sexual, he would be facing a 10-year maximum imprisonment because that would be a Class G felony.
I'm not sure what the particular penalty associated with that crime is.
The penalty for aborting after a sexual would be more severe than the penalty for the sexual assault. The Journal of the American Medical Association that estimates that 65,000 pregnancies have been caused by rape. So the scenario is far from speculative.
The justices also raised questions about how these laws might affect women in medical emergencies, such as cases of preterm premature rupture of membranes, known as pre-prom, which is a serious condition.
Pre-prom, do you know what that means? Preterm premature rupture of membrane. One of the the ACOG amici brought up the case of Josely Barnica, who went into premature labor at 17 weeks. There was a fetal heartbeat. Her fetus was not yet viable. She suffered an infection that killed her because medical providers were unable to give her the health care that she needed. For 40 hours was pray that someone would help her so she could go home to her young child. That is a scenario that could easily, perhaps has easily, played out here in Wisconsin under your interpretation.
I'm not sure, Justice Karofsky. I'm not a doctor, and I would say that the interpretation of 940.04 that we're positing is the legislature's judgment as to what the law should be.
Hold on, I'm not done.
Yeah.
Justice Kowalski's final comments were direct. She argued that this interpretation of the law could keep pregnant women from getting the life-saving care they might need.
I can't think of anyone else other than pregnant people who are denied medical care under the law. Can you?
The FDA regulates particular types of medical treatment that are provided to people. I don't think the notion of the government restricting a medical procedure is new. I think that there's a long-established history in this state of prohibiting abortion.
That what you are asking this court to do is to sign the death warrants of women and children and pregnant people in this state. Your interpretation, they could all be denied life-saving medical care while the medical professionals who are charged with taking care of them are to sit idly by. This is the world gone mad. I don't understand how that is not the crime here.
As this important case wraps up, Wisconsin's justices must now decide on laws that could change health care and rights for women across the state.